Hello, everyone. My name is Giovanni Nogales, and I'm a paralegal here at Laos Parker. Thank you for joining us for this new webinar series with the Home Care Association of Louisiana. Today's webinar is entitled Data Privacy Issues and Regulations, HIPAA and Beyond. Our presenter for today is Heidi Kocher. Heidi Kocher is a partner with the law firm of Laos Parker. She has over 20 years of experience advising and defending healthcare clients on legal and regulatory matters affecting providers of all sizes. She is an expert in all aspects of compliance and privacy programs, including developing and deploying policies, procedures, and training. Her experience includes serving as a chief compliance officer and the chief privacy officer, implementing the various requirements and aspects of corporate integrity agreements, and responding to and defending audits for Medicare, Medicaid, and private insurers up through the ALJ level. She received her JD from Georgetown University Law Center. She is licensed in Texas and Maryland and admitted to the U.S. Court of Federal Claims. She is certified in healthcare compliance. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we will address as many as possible at the end of the presentation. So without further ado, I present to you your speaker, Heidi Kocher.
Thank you so much for that kind intro, Giovanni. Next slide, please. So, of course, being a lawyer, I have to give you my little disclaimer. This webinar is for general information only. It does not constitute legal advice and should not be used as a substitute for seeking legal counsel. Even though we are attorneys, we are not your attorneys specifically, and outcomes can actually differ based on different fact scenarios. Also, I am coming off some upper respiratory stuff, as so many people are, and I just had a coughing fit about 15 minutes ago. I will try to mute myself so I don't cough in everybody's ear, and I will try to give you guys warnings when I feel a coughing fit coming on, but I just wanted to give you some heads up that may happen occasionally, and if it does, I really apologize. I thought I was over all of it, and today, it's just one of those days. All right, next slide, please. So this is a brief agenda of what we are going to cover. I want to kind of go into why this is important, give you guys an idea of the scope of the number of complaints and incidents and the penalties that are out there. Then we're going to talk some about HIPAA security, and then we're going to talk about breaches, and then OCR's right of access initiative. We're going to talk about the relatively new information blocking rules. I'm going to touch on social media and then discuss the future of HIPAA, and then we'll talk about some compliance tips. Next slide, please. All right, so why is this important? I think I wanted to give you guys an idea of just how big of a scope this issue is. So as of the end of October, which is when OCR has data through the end of October, they've received almost 345,000 complaints of privacy violations. 60% of these complaints are resolved with corrective action plans, and 33% are found to have no violation. So these are actually pretty good numbers. That a third have no violation, and the bulk of them are resolved with corrective action plans. Although some people may say, well, a corrective action plan still is no fun because then you have to do things and you have the government looking over your shoulder. But still, usually a corrective action plan means there are no monetary fines. 138 cases were settled with monetary fines, and we've had close to 2,000 referrals to the Department of Justice for criminal prosecution involving the knowing disclosure of PHI. And in calendar year 2023, there were 546 incidents reported to OCR involving 500 or more individuals, right? That is the breakdown or the cutoff for when things get reported publicly. and posted on the so-called wall of shame. 83% of those in calendar year 2023 were hacking or IT incidents. And this is why when I get into the security rule stuff, you'll see why this is so important. Another 14% were unauthorized access or disclosure. And again, the bulk of these involved some form of electronic access to your IT resources, be it a network server or the email or an EMR. So you can see over 97% in calendar year 2023 involved some kind of, again, security incident, hardware, software, what have you. Next slide, please. So OCR can and does impose civil monetaries for failures to comply. Again, we have a number of those. They are tiered, with the tier 1 being that the covered entity or business associate committed the error without having reasonably known about the breach. And the penalties here, the civil monetary penalties, range from $137 up to $69,928 per incident, up to a maximum of just over $2 million. And for all of these, the maximum in the latest set of regs is $2 million. The second tier is when the covered entity or business associate either knew or should have known of the error if it had exercised due diligence, even though it wasn't willful neglect. And here your penalties go up to $1,379, and again, topping out at $68,928 per incident. The third is where the covered entity or business associate acted with willful neglect, meaning you knew what you had to do, but you didn't do it. But then you corrected the issue within 30 days. And the costs here jump significantly. The penalties here start at $13,785, and again, top out at $68,928. And the fourth tier is where the covered entity or business associate acted with willful neglect and failed to correct the issue. Here, the penalties are the flat $68,928, again, capped at a little over $2 million. And this kind of situation, we've had a number of these over the years. There's one, and I think it's in the slides, one incident where somebody reported, or OCR came in, did an audit, found some things wrong. The covered entity, they told the covered entity fix it. They came in sometime later, did a re-audit. The covered entity had not fixed it. OCR said, look, you need to fix it, and here is how you fix it. They gave them the exact steps to take. And OCR came back sometime later, and the covered entity had still not fixed it. At that point, that's basically thumbing your nose at the government, and that falls into the fourth tier and gets you the highest penalties here. Next slide, please. In case people think these are only civil monetary penalties, we also have potential criminal penalties. And as I said on the earlier slide, there are close to 2,000 referrals to the Department of Justice for criminal penalties for breach of HIPAA rules. This is also tiered. There's only 3 tiers here. So if there was a reasonable cause or no knowledge of the violation, the max is a year in jail. The second tier is if somebody obtains PHI under false pretenses, the potential penalty is 5 years in jail. And the third and most serious tier is if you obtain PHI for personal gain, that will get you up to 10 years in jail. And yes, people have gone to prison for criminal penalties. So as you can see, there's a lot of misfeasance and malfeasance out there. Again, thousands and thousands of complaints. I read an article just this morning that said that OCR has been so dismayed by all of these incidents and still the continuing reports that they are really going to be stepping up enforcement in 2024. And just as a background, remember that HIPAA was passed in 1996. The privacy rule went into effect in 2003, so that's 20 years ago. And the security rule went into effect in 2005. I would not be surprised if some of our listeners today have kids in college who are younger than the HIPAA regs. So if you think about that, just realize that the government really expects that at this point you have these, you have looked at these rules and regulations, and you have implemented not just privacy program, but a security program as well. Next slide. So speaking of a security program, again, here is the HIPAA rule, and there are hyperlinks here. When we send out the slides afterwards, you will get the hyperlinks so that you can click on through to them and just get the resource. But again, as I mentioned, the rule was published in February of 2003 and became effective in 2005. And just to recap, it means that covered entities must ensure the confidentiality, integrity, and availability of all EPHI, and here are 4 keywords that they create, receive, maintain, or transmit. So those are 4 words you want to think about: create, receive, maintain, and transmit. Under the security rule, covered entities must identify and protect against reasonably anticipated threats to the security or integrity of the EPHI. They must protect against reasonably anticipated impermissible uses or disclosures, and they must ensure compliance by their workforce. So again, this is on all covered entities' shoulders. And as home health and hospice agencies, you all are covered agencies, are covered entities. Initially, business associates were liable for this via the BAA, but after the passage of the HITECH Act and the HITECH rules were published in 2013, business associates are now independently liable, meaning it's not just the BAA that makes them liable for compliance with the HIPAA security rule, but now they have independent and separate obligations to OCR to make sure that the data is protected and that they have a security, HIPAA security program themselves. Next slide, please. So the key thing under the HIPAA security rule is the security risk assessment. Everything else revolves around the security risk assessment. And if there is one thing you take away from today's presentation is just do it. Just do a security risk assessment. What happens if you have any kind of a breach or a complaint is OCR will come in and they will immediately ask for 3 things. Number 1 is going to be your security risk assessment. They will want a copy of that. Number 2 is going to be a copy of your security policies and procedures. And number 3 is going to be evidence that you've trained your employees on this. So everything, as I said, just revolves around the security risk assessment. Now, a lot of people say, oh my gosh, security risk assessment, pain in the you-know-what. Yes, it is. The way I analogize it is it's kind of like mowing your lawn, right? There are tools, and I've given you some links here. There are tools out there that you can do a security risk analysis on your own. Having said that, I have gone through these tools, and frankly, they can be kind of confusing. And also, I suspect that you all have better things to do. And this is why I analogize this to a lawn service, right? Can you mow your own lawn? Of course you can. Absolutely. It's not that hard. The quick question becomes, do you want to do it? Now, I don't know about you, but I have better things to do than to mow my lawn. So I outsource my lawn maintenance to a lawn service company. And a security risk assessment can be this way as well. You can definitely outsource this There are companies that do it for actually a very reasonable price. And if you're interested, email me afterwards and I will give you some references. But a security risk assessment is something, as I said, you can do yourself, or you can outsource it. Doesn't matter as long as you do it and you document it. The next point is that this risk assessment and remediation is a continuous and ongoing process. It is not a one and done. OCR recommends that you do a security risk assessment annually. And certainly you have to do one after you have a major change in technology. So for example, if you switch EMRs, that is a major technology change. You need to do a repeat security risk analysis. If you have a breach of any kind, that is considered a trigger for performing a new security risk analysis. So this is not, you did it in 2013 and now you're good. No, you should be having security risk analyses every single year. And again, we have had situations where not just that OCR comes in and asks for a copy of the security risk assessment, they ask for copies going back 6 years. And under the HIPAA regulations, you're required to keep the copies for 6 years. So again, this is an ongoing process. As I said, if there's one thing you take away from this webinar is do a security risk assessment. This in and of itself really will help protect and defend you if you have any kind of a breach. As said, I've given some links here. The top is HHS's security risk assessment tool. NIST, the National Institute for Standards and Technology, actually has a toolkit application. It's discussion about HIPAA and things to do right. That toolkit is honestly a little bit dated, but still it has some good information. If you're interested, there is 2010 guidance on the risk analysis requirement under the HIPAA security rule. This was published by OCR. So again, 2010, let's see, that's at least 13 years old now. So again, OCR expects you all to understand your obligations and have implemented appropriate controls for that. And then finally, there's a separate thing of HHS security rule guidance material. All really good resources. I will confess that if you're struggling with insomnia, you can start reading these, and these work better than Unisom. But again, very important that you look into these. Next slide, please. All right. One of the things that people always tell us is, oh, we have to encrypt our devices. And I want to be really clear on encryption. People mistakenly believe that encryption is required by the security rule. Now, technically, it is not required by the security rule. However, with the state of technology as it stands today, at this point, encryption is really the only way to achieve security. So therefore, you really should be encrypting all your devices, especially those that you use in the field. If your staff use personal cell phones in the field, those must be encrypted. If you use an iPad for documentation, that must be encrypted. One of the things to remember here is that when you have a breach, you have to do a 4-factor analysis about the breach. And if the PHI cannot be accessed because it is encrypted, then you tend to have a favorable 4-factor analysis. And I'll talk about that in a little bit. And one of the things that I want to really bring to the fore is approximately 1/3 of the settlements and resolution agreements involve the loss or theft of unencrypted devices. So you can see why encryption is pretty important. And again, a lot of this stuff is important to document. So don't just say, oh yeah, we've got it encrypted. Write a memo to file that says all of our field or devices are encrypted using whatever the method is. and then, talk about how you encrypt them. Field staff are not allowed to use personal phones, or yes, we have encrypted them and we have wipe options in case of loss or theft. So you want to think through these things. There's the guidance here on how to render unsecured PHI unusable, unreadable, or indecipherable to unauthorized individuals. Unauthorized individuals, you should read hackers or ransomware. So again, there's guidance out there. And the NIST guide to storage encryption technologies is also useful reading. Again, a tad dated, but the principles are absolutely valid and good and still usable. Next slide. So one of OCR's big concerns is what we call PHI out in the wild. And again, this is PHI, again, in the field, not in your offices. And we've had a number of incidents. So Lincare in 2016, this was a settlement in 2016. This was the regional manager for the DME company. And what she did was she kept patient files in her car and in her personal residence. In August of 2008, at the, conclusion of some marital issues, this regional manager moved out of her residence and left her husband in the residence. In December, the husband notified OCR that he had found patient files under a bed and in a kitchen drawer, I guess in like one of those little, computer type cubbies in the kitchen. As a result, he had access to 278 patients' data. OCR found that Lincare, which is a pretty good sized company, didn't have any policies regarding safeguarding of PHI taken off work premises. And Lincare paid almost $240,000 in fines, which is, a little under about $1,000 per patient. So just think about that. University of Rochester Medical Center in November of 2019 led to a settlement, a $3 million settlement and a 2-year corrective action plan in the form of a resolution agreement. And this is because they had failed to encrypt laptops and flash drives, and they had had over the years a number of losses in 2010, 2013, and 2017. After the first one in 2010, you would think that they would have put things in place. Certainly after the second one in 2013. But when you have a third loss of unencrypted devices, that's just, baseball, 3 strikes and you're out. So they got a pretty significant penalty. North Memorial Healthcare in March of 2016, they had a $1.5 million fine after an unencrypted laptop was stolen from the employee's car. Again, unencrypted, no security policies, no risk assessment. So these things all swirl around the 3 things that I mentioned: the security risk assessment, policies and procedures, and training for your employees. Next slide, please. I'm not going to go through this one. This is real briefly just some other recent HIPAA resolution agreements involving improper disposal of PHI. An unsecured server. Again, this was, an IT thing, and they had PHI exfiltrated, and part of their fine was because they failed to conduct a security risk analysis. We have employee snooping. The hospital paid significant money, again, because they failed to do a security risk analysis. They failed to get the breach under control, and they had not properly trained their employees. And one of the bigger ones that I think is rather interesting is this hacking breach here at the Oklahoma State University. Nearly 280,000 patients had their data exposed, and the breach was undetected for almost 2 years. Oh my gosh, how does that happen? How can you not have a breach undetected for 2 years? So OSU was fined for failing to conduct what again? A security risk analysis, and failing to implement a security incident reporting system, and failure to provide timely breach notification. I mean, that's almost a given, especially if the breach was undetected for 2 years. And they paid $875,000 in fines. And don't forget, this is in addition to the money they spent to correct all of these issues. So save yourselves a little bit of money, spend a little bit of money. This is one of these things where you can spend a little bit of money and save yourselves a lot of heartburn and headache and expense on the back end. I'm going to repeat it again. If there's one thing you take from this webinar, do a security risk analysis. All right, getting off my soapbox. Next slide, please. So the next thing I want to talk about is the HIPAA breach notification rule. Again, here is a link to the federal regulations. And here is where I want to talk a little bit about the 4-factor test. I'm going to mute for a minute because the cough's coming. Sorry about that, folks. So an impermissible use or disclosure of PHI is presumed to be a breach unless the covered entity or business associate can show a low probability that PHI was compromised based on an analysis of 4 factors. And number 1 is the nature and extent of the PHI involved, including what kinds of identifiers you have and the likelihood of re-identification. Sometimes breaches can involve de-identified PHI. There have been some interesting studies out there that show actually how easy it is to re-identify the de-identified PHI. You would be shocked. The second factor is who is the unauthorized person who used the PHI or to whom disclosures were made. In many cases, what we're seeing is with ransomware, data is exfiltrated to a hacker. So obviously that would be a pretty serious unauthorized person. And then they use the data for a variety of improper things. Here, the factor number 3, whether the PHI was actually acquired or viewed. And this is where the encryption comes into play. If you can't actually view the PHI because it was encrypted, then your likelihood of a breach becomes much, much, much lower. So that is why encryption becomes so important. And then finally, the extent to which the risk to PHI has been mitigated. If it was a loss of a device, were you able to, get the device back? If it was a device where you have remote wiping capabilities, were you able to remotely wipe the device? That's some of the things that we're talking about here. And remember that under the breach notification rule, you have 60 days under the federal rules, federal HIPAA law, to notify patients. Next slide. OCR has found major issues in notifications to patients and reporting of data breaches. We talked about OSU. The breach went undetected for 2 years, almost 2 years. So, the patients whose data was initially accessed a year and a half prior, they were never even notified. And here are just 2 examples of entities that paid significant fines for delays in reporting. So Presence Health in 2017 paid $475,000 for a 42-day delay in reporting. 42 days is not very long. It's basically, about 6 weeks. So that's not very long at all. Centera Health, they paid a $2.175 million fine. And this is the entity where I said, remember, OCR came in and told them how to do it. So they failed to properly report the breach even after OCR explicitly told them what to do and how to do it. So don't be caught with your pants down like these entities. Again, security risk analysis, make sure you are on top of being able to notify patients. Next slide, please. So it's not just the federal government that is very concerned about HIPAA security and data breaches. We see state attorneys general getting into the data security and breach notification prosecutions as well. November 2022, Aveanna Healthcare, they had phishing attacks and had some employee accounts hacked. They only have, well, I shouldn't say only, a PHI of 4,000 patients and employees was exposed. And they didn't move very quickly. Again, the breach was discovered in August. They didn't notify patients until February. And at this point, the Massachusetts State Attorney General stepped in and said that their security breach program did not meet the requirements of the Massachusetts data security regulations. And so Aveanna, this home health agency, paid a $425,000 settlement to the state attorney general. And then they had to implement a comprehensive information security program. And that corrective action plan is 4 years, which is longer than the typical OCR corrective action plan. I will note that on this breach, it also led to a class action lawsuit by the affected patients. That, of course, is still in process. We don't have the outcome, but these are kind of like dominoes that start falling. And again, this is just the state attorney general and state law. It has nothing to do with the federal OCR. We had a situation with AMCA, American Medical Collection Agency, for about, what is that, about 7 months, 8 months, August 2018 through March 2019, they had a breach of their systems. And they had, in Texas, 1.4 million Texans data was exposed, but there were 7 million people total. I don't remember the numbers for Louisiana. But in any case, 41 state attorneys general got involved and sued, and AMCA agreed to a 7-year corrective action plan to implement an information security program, which includes the hiring of a CISO, a Chief Information Security Officer, and paying $2.8 million in fines to these 41 states. Of course, one of the big ones is the Equifax one that happened last year or the year prior. There was a nationwide $600 million settlement. Texas itself collected $10.9 million, and I did not find the amount that Louisiana collected from Equifax. But again, a pretty significant settlement on all of these. So again, it's not just the federal government, it's the states that are starting to get involved in this, especially with them developing and passing new consumer data privacy laws that go beyond HIPAA. And again, in some states, you have patients under state law are able to file lawsuits. All right, next slide, please. This next two topics are kind of two sides of the same coin. We have the patient right to restrict disclosure. And again, the patient always has the right to restrict the disclosure of information. A lot of people say, well, can I share information with family members? Well, yes, that's okay if the patient doesn't object or disagree. So for example, if you are doing intake on a patient and you are in the patient's home and they have a family member sitting there, you know, one of the first things you can say is, you know, We may be discussing sensitive medical information. Is it okay if we talk in front of the family member? And if the patient says yes, note this in your records, and you can go from there. Likewise, if the patient doesn't object, if they say, yeah, please tell my significant other or my family member, then it's okay to discuss information. Beware of disclosures involving mental health. There are some separate rules that I'm not going to get into because there's too much in this presentation already, but there are some additional rules for mental health. So beware of that. And often when you have home care patients, you may have a mental health component as well. If the patient is incapacitated, you may share information with family members if in your professional judgment you decide that the patient would not object or it's in the best interest of the patient. And again, these are the kinds of situations where I would just, make a quick note. We determined that it is the best interest of the patient to share information with her husband, right? Remember, when you share, only minimum necessary. So if you have a patient to whom you are providing, let's say, some in-home physical therapy because they've had a joint replacement, then you shouldn't be discussing psychiatric meds, even if the family member says it's okay, because the information about psychiatric meds is above and beyond the minimum necessary to deal with treating the joint replacement. So that's just an example. Again, there is some good guidance that OCR has published over the years, and the link is there. Next slide, please. Okay, so the flip side of the patient's right to restrict disclosure is the patient's right to access information. And OCR has had numerous complaints, and I'll talk about them in the next slide, numerous complaints about patients not getting their medical records promptly. Again, the federal rules grant the patient's right to access information in what is called the designated record set. And again, I'm not going to go into the definitions, it's sort of beyond the scope of this. But they have the right to access the designated record set. The personal representative of the patient also has the right to access the PHI, as well as to tell the covered entity to transmit a copy of PHI to a designated person or entity. I often see confusion about whether a personal representative has the right to do such certain things. And assuming you have, something like a guardianship or a power of attorney or something like that, basically the personal representative stands in the shoes of the patient. And if the patient has the right to do it, then the personal representative has the right to do it. So as I said, OCR has received many complaints about entities failing to give patients the right of access. There are stories out there, and I didn't put them in here because it's just too much information, but there are stories out there about patients that have gone back to covered entities 3, 4, 5 times to get, particular records, and it takes them years to get their records back. So OCR started on this right of access initiative. It's been going on, I think 2023 was the second or third year, but in any case, we now have 45 entities, large and small, that have entered into resolution agreements. They've paid fines to resolve this and entered into, again, corrective action plans. And OCR has been adamant that this has been so successful, and they still get so many complaints, that they are really going to push this right of access initiative in 2024. So again, another thing that you need to take away from all of this is if a patient or an authorized individual requests patient records, promptly, please, promptly make sure you disclose those records and turn them over. Next slide, please. So our next agenda item is the new, relatively new, information blocking rules. These were published in May of 2020, and the 21st Century Cures Act, which was passed in 2016, authorized the OIG to investigate and impose penalties for information blocking. So in May of 2020, the Office of the National Coordinator, the ONC, Office of National Coordinator for Health Technology, published a rule defining information blocking. And they use the term EHI, which is Electronic Protected Health Information. It pretty much lines up with PHI. There's a few minor differences not important for the purposes of this. Of course, it doesn't include psychotherapy notes or information used or created for use in a civil, criminal, or administrative proceedings. So there are some limitations that, again, kind of line up with the HIPAA privacy regulations, but again, a slightly different term. So here is the key term, information blocking. This is a practice that is likely to interfere with access, exchange, or use of EHI, and the healthcare provider knows that such a practice is unreasonable and likely to interfere with, prevent, or materially discourage access, exchange, or use of EHI. There's a number of exceptions, such as an individualized assessment of risk of harm. So again, this is, again, if you think that disclosure to a patient of mental health information might be harmful, that's one of those exceptions. It's essentially the same type of harm that a covered entity can cite when they deny access to PHI. But to give you an idea of why this is important, between April of 2021 and September 30th of 2023, so a year and a half, they received 870 plus claims of information blocking, and 60% of these claims of information blocking came from patients. So patients are very frustrated and upset by this. Next slide, please. So as a result of these rules, the final rule imposes penalties on health IT companies. And in July of 2023, so just this past year, and at this point, it includes health info networks and health information exchanges. So think of things like an ACO if you're exchanging information, or you are part of an OCA, an OHCA under HIPAA. Nobody talks about OCAs anymore. But those are the kinds of things that we are thinking about. In October, HHS published additional information blocking rules for some healthcare providers, and they are about to go into effect. The OIG is, again, the main investigative agency, and at this point, these rules are only aimed at hospitals and MIPS eligible clinicians. So MIPS is the Medicare Incentive Program system, and where certain individuals certain providers can get additional Medicare funds if they can attest to meaningful use, quote unquote, of EHI. So the MIPS eligible clinicians at this point are physicians, DOs, nurse practitioners, PAs, PTs, OTs, and social workers. So if anybody gets a bump up or a reduction under MIPS, they are covered by these new rules. HHS has specifically said they will apply these information blocking rules to other clinician types in the future via other rulemaking. Patients can now report potential blocking via an information portal. So patients can literally go onto the internet and put in information about what they believe is information blocking. The penalties are that the clinicians and the hospitals are denied as a meaningful user, and they can be removed from the Medicare Shared Savings Program. So again, there are some financial penalties involved. I don't have exact numbers here because it kind of depends on the particular clinician and exactly how they look, how they calculate their reimbursement. Penalties that are going to be imposed will be published on ONC's website. This is going to be similar to OCR's Wall of Shame, where you have reported breaches of 500 or more individuals. And you can go onto the Wall of Shame and just scroll through hundreds and hundreds, thousands of breaches of 500 or more individuals. So these rules are going to go into effect soon, and that's why this is important. So next slide, please. So here, so they've already opened up the portal, and you can see that, again, in the space of about a year and a half, they've had 923 submissions, 856 of which really do look like potential portals or potential claims of information blocking, and the total number of submissions that didn't appear to be claims of information blocking because the patient either didn't know what they were talking about or didn't talk about the right kind of information. There were only 67 of those. So again, it looks like the bulk of the complaints are valid. And I want to look at this bar chart here. So patients, again, are the bulk of the claimants, but look at the third bar, another healthcare provider. I think that in the right circumstances, home health agencies could use the information blocking rules to their benefit. So one of the issues we always have with home health and hospice agencies is getting timely information from physicians and hospitals, discharge paperwork, referrals, prescriptions, signatures, and so on and so on. So I think in the right circumstances, home health agencies and hospices could use these information blocking rules to try to dislodge the needed information from the referring or prescribing providers. So just something to keep in the back of your minds, particularly if you have a terribly vexatious situation. Next slide, please. I want to briefly touch on, I said this was beyond HIPAA. Don't forget that Louisiana has state privacy laws. They parallel HIPAA rules, but there are some significant differences. First is that the healthcare provider must provide a copy of any information related in any way to a patient. So it's not just the definition of PHI, but any information. And you have to give the patient any information that was transmitted to any company, agency, or person. Remember that under HIPAA, we're only dealing with covered entities and business associates, right? Anything else is an improper disclosure. So, you have to sort of think through some of these things. On the right of access under Louisiana law, patients have to be given access to their ePHI within 15 days of request, not HIPAA's broader timeframes. So make sure that you are able to do so within 50 days. If the patient gives a notice that you are violating their rights, then you have only 3 days to correct a violation, and it's not 3 business days, it's 3 calendar days. So again, you want to make sure that you have your, information, returning information to a patient in response to a patient request. You want to make sure that those processes are nailed down and are very well controlled. If they have to subpoena you for those records because you haven't turned them over, then the healthcare provider is liable for attorney's fees for the subpoena. And finally, what we see are moves to consumer data privacy laws. Louisiana also has a consumer's right to know, which states that healthcare providers submit certain data to the Louisiana Department of Health for data pricing and transparency, and that has to be maintained by regulations at least as stringent as HIPAA. And also note that the Louisiana Department of Health has its own HIPAA policies, and these policies apply to individuals receiving Medicaid as well as providers and licensees. Now, I've scrolled through these policies. They're essentially HIPAA conversant. They were drafted in 2003 and updated a little bit after high tech, but they haven't been touched since. But just be aware of that. Next slide, please. Other laws that can come into play are identity theft laws. Just be aware that Louisiana has an identity theft law as well. And the list of personal identifying information, it's not identical to, but it is very similar to many of the items on HIPAA's list of 18 identifiers. So just be aware that if you have a breach and it is one of your employees or staff members, they could run afoul of the identity theft law as well. And also, if your victim is 60 years or older, so most of your Medicare beneficiaries, under 17, Medicaid beneficiaries, or quote unquote, a person with a disability, and identity theft is proven, there is mandatory jail time that attaches. Next slide, please. These next two slides are actually Texas privacy laws. I left them in here. I know that we have some locations in Louisiana that are close to the Texas border. So in case you are covering Texas patients, I left these in here. I'm not going to cover them in depth. Just know that they're there. Giovanni, can we skip 2 slides now at this point, please? Thank you. Okay, HIPAA and social media. Social media has turned out to be a real bane of a problem. And CMS actually published a memo on long-term care staff of use of social media, especially photographs, and I put the link here. I want to be clear that even though this is actually about long-term care staff, the principles in there apply not just to nursing homes and similar and rehab facilities and so on. They're going to apply out in the field and to home health agencies and hospices as well. So you really want to make sure you understand what is happening with social media. You have to have a policy in place and have your staff sign an acknowledgement of this. There are so many issues with social media. I've had multiple HIPAA breaches that I've resolved where a provider has a staff member that has placed information on social media, and you just don't want to go down that road. Again, because most providers haven't done a security risk analysis. If you're photographing, make sure you obtain patient consent, and you want to limit the distribution and the use of those photographs to minimum necessary. Any posting that involves PII, personally identifiable information, requires patient authorization. If you think you are going to be photographing and using that and including it in your EMR, you know, particularly if you're dealing with wound care, make sure you include patient consents and authorizations in your initial packet when you bring the patient on for the first time. Remember that HIPAA applies to personal social media accounts as well as corporate ones. Therefore, to the best of your ability, see if you can monitor channels. Set alerts for your entity names like a hashtag so that you get an alert if, you know, something is posted on Facebook hashtag ABC Home Health. You want to nip this thing in the bud. And with social media, I'm going to put on here, beware of responding to online reviews, especially negative ones. It is the online reviews typically where people get so mad and they get emotions involved, and then they end up disclosing PHI, and we don't want that. Next slide, please. I do want to put out here that the American Nursing Association has actually put out a set of ethics for registered nurses for social networking. And the reason that I put this out here is because many states will look to these. Some states incorporate these by reference in their nursing education laws, and they actually say we will abide by these sets of ethics. But if nothing else, these codes of ethics are evidence of the standard of care, and for that reason can be used in licensure actions. And if you've got a licensed individual who is posting on social media, this could have fallout not just for your agency in terms of an OCR investigation and fines, penalties, but it could have fallout for the licensed individual as well. And so again, the boards will look to these kinds of principles. I'm not going to go into them in depth because I know we want to finish up quickly, but look through these and realize that there are actually nursing ethics standards out there on the use of social media. Next slide, please. I just want to point out that we have OCR settlements involving social media use. And as you can see, the first three were actually responding to negative online reviews where the providers posted information or ended up disclosing information about the patients. In 2016, we also have an individual who posted a picture on Snapchat of an Alzheimer's patient who was wearing only a bra and not a top. The photo was on Snapchat for only 24 hours. I'm putting this one in here because the CNA was not only fired, she was also sentenced to 30 days in jail under her state's laws. So again, be aware that some of these things can have criminal consequences, not just fines. I found a report, ProPublica published a report of 65 reported incidents of healthcare workers posting photos or videos of patients. I'm sure there are far more than those out there, and it is a big deal, and it is something that OCR is getting very upset about. So again, make sure you understand how your social media is being used, have a policy in place, and have your staff acknowledge that they understand the policy. Next slide, please. All right, so again, HIPAA was enacted in 1996, really long before, well, before the internet became widely used. And again, we've talked about how old the privacy rules and the security rules are. In 2021, OCR published a notice of proposed rulemaking to actually update HIPAA regulations, and they received close to 1,400 comments in response. OCR has said repeatedly that the final rule is likely to be published in late spring or summer of this year. So you want to be watching out for those. Some of the nice things here are that the proposed language actually expressly permitted covered entities to disclose PHI to home and community-based service providers. In other words, home health agencies and community hospices, in order to provide or coordinate the health-related services. So this will really be good. I'm not sure what kinds of penalties will be attached if covered entities fail to disclose this PHI, and to what extent it will supplant the information blocking rules or maybe complement them, but it is definitely something you should be watching out for. We anticipate also that there will be additional changes to the security regulations. Again, HIPAA or OCR has been very concerned that people aren't paying attention to the security rules. They're also going to have a proposed language permitting individuals to explicitly direct how to share their ePHI among providers. And finally, and this is such a blessing, it will probably eliminate the need to obtain a patient acknowledgement that they received the notice of privacy practices. Yay, one less piece of paper in people's files. All right, next slide, please. So watch out for those new rules coming up. Other slides or other laws that may impact you, again, just really briefly, the Federal Trade Commission also has red flag rules on identity theft. That is becoming an issue in the healthcare sector. We also have state laws on data privacy beyond PHI. There's a couple of them here. A lot of states are getting on this bandwagon. Texas passed a Data and Privacy Security Act effective July 1st. Applies to all companies conducting business in the state, but there is an exemption defined as less than $15 million in revenues for home health agencies. So that's a good thing. They didn't have a specific definition for hospices, but if you're under 19 million in revenue, you don't have to comply with the Texas data privacy law. Where does this come in? This is going to be useful if you're doing some of these remote patient monitoring things, or it will apply. So if you're using, like some of the apps that are out there, the sleep monitoring, the Fitbits, the Apple Fit, or whatever they call it. That's what these laws protect. There is a groundswell to come up with a national law, since we now have 6 states that have done state laws. And of course, being states, each law is a little bit differently. But so we've got this coming up, so stay tuned and watch for that. All right, real quickly, wrapping up here, tips and best practices. Next slide, please, Giovanni. You need to know what the requirements are, and you want to have a person whose job it is to understand privacy and security. Typically, this is a chief privacy officer. If you're a small entity, it's okay to have somebody who has multiple jobs, but make sure they understand this and they have sufficient time to do privacy and security. If you do not have sufficient time, it's okay to outsource this function, and there's ways to do that. Make sure that your policies are up to date and that you have the correct policies. And again, make sure you conduct a security risk analysis. Please, people, one thing, conduct an SRA. You want to do it annually and after major changes in technology or after you've had a breach. And here's the thing, most providers have already had a breach at this point, you just don't know it. Either you've had a breach and you found it, or you've had a breach and you haven't found it. So there you have it. Train your staff. You should be training new employees within 90 days. Others are recommended to be trained annually. Be ready for a breach. Again, I'm willing to bet a box of donuts that most of you have already had breaches. You just don't know about it yet. Have individuals designated and a toolkit ready to how to respond. You want to monitor your social media or just not have social media. And beware again of responding to online reviews. Consider purchasing, you should be purchasing cyber liability and insurance and making sure that your coverage is sufficient. Again, cyber liability insurance is going to help you pay for some of these things. Won't pay for the fines and penalties, but it will help you bring in, if you need a forensic IT person, or if you've paid ransomware or some of the other things that you need to pay for. Cyber liability insurance will help pay for it, but make sure you have sufficient coverage. And finally, consider if you can use the information blocking rules to your advantage. All right, that's the presentation. Remember, there is no stupid question in this field. If you have any kinds of doubts or questions, please ask. And next slide, Giovanni. Here is my contact information. Please feel free to reach out. And Giovanni, do we have any questions at this point? I know I'm a few minutes over. I apologize.
Yeah, we have, I think, one question. So it says, it is not a HIPAA violation for a government from another state to ask another government from two states over for records of a certain group to see if they are getting life-saving service. I've had two friends who wanted to sue but not sure how to go about. Both did not give permission nor ask their permission for their information to be shared outside of their healthcare provider.
Okay, so this is a really interesting situation, and you're going to hate the answer, is it depends. We have had, and this comes up in the reproductive right and the transgender care. There is a lot of stuff going on, and honestly, this is changing week by week. And so people are going to hate my answer, but it's going to be, it depends in part on the state where the care was provided and the state that is asking for the information. So it's really going to look at some particular state rules and regs. And again, there are federal protections that are being bandied about. You know, in the reproductive care arena, the administration has said they will take steps to protect this data. So if somebody wants to reach out separately, it's a little bit more involved and complex than a simple answer that we can give here on the webinar.
Yep, so that was the only question. So thank you so much to our presenter, Heidi Kocher, for that information, and thank you to our attendees. I'll be sending a copy of the PowerPoint slides tomorrow, and if you have any further questions, reach out to Heidi herself, and have a great Tuesday. Talk to you later.
Thank you all. Thank you all. And remember, do a security risk analysis, please, 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 please. That's my spiel.
Thank you all. Bye.
Thank you all. Bye-bye.